Hello, everybody. I'm George from Ireland. So I've just been watching a interview with the late Lord Denning from 1979, that renowned judge who died in about 1999. It gave me a bit of inspiration. And that led on to my next topic, which is judges as lawmakers. So do judges make law or not? It appears they do, a bit, in England and Wales at any rate. So this is a debate which has raged for centuries. Some people say they've got no legitimacy to fashion laws. That's got to be up to a legislature. That would be undemocratic otherwise. We don't want critarchy. Or, as the good book says, when judges ruled the land, it was bad. So Sir William Blackstone famously published these commentaries on the laws of England in the mid-18th century. And he came up with a declaratory theory, which is that judges declare what the law is, they do not create law. Lord Simmons talked about this in Midland Silicon Limited against Scrutton's Limited 1962. And here's what Simmons said. Nor will I easily be led by an undiscerning zeal for some abstract kind of justice to ignore our first duty, which is to administer justice according to law. The law which is established for us by an act of parliament or binding authority of precedent. Close quotation. So there is a spirited scholarly debate about this, about how the judiciary do make law in limited circumstances, even repeal it. And this is developed bit by bit down the centuries to try and keep the law relevant to the social situation, to economic developments, to inventions and so forth, to deal with situations which are not provided for by statute. So and Lord Denning was saying about this, how in the 70s, how unmarried couples acquired rights, cohabitees, which they didn't have previously, and living together outside marriage was increasingly common since then. So judges sometimes feel that they are obliged to create law if there is no statutory provision governing that situation. In Gillick against West Suffolk and Wisbech Area Health Authority in 1986, this was about minors. Should they be given contraception? So there was no law on the case, and Lord Scarman had to sit on the case because, of course, the age of consent in England and Wales is 16. Would that not be being complicit in underage sex? Is that like encouraging paedophilia, therefore? Is that accessoryship? But anyway, Lord Scarman said this: neither the statute nor the case law has ruled on the extent and duration of parental right in respect of children under the age of 16. More specifically, there is no rule yet applied to contraceptive treatment, which is a special promise of its own and is a latecomer in medical practice. It is therefore open to the House of Lords to formulate a rule. Close quotation. So anyway, they decided that these minors, they didn't have the legal capacity to consent to sex, but nevertheless, medical practitioners could prescribe them contraceptives without informing the parents, without fear of the doctors being prosecuted. So Lord Reed wrote an essay about this, The Judge's Lawmaker, which he published in 1972. And this is what he said. We do not believe in fairy tales anymore, so we must accept the fact that for better or worse, judges do make law and tackle the question, how do they approach their task and how should they approach it? Close quotation. So in National Westminster Bank and Spectrum Plus 2005, Lord Nichols had the following to say. The common law is judge-made. For centuries, judges have been charged with the responsibility of keeping the law abreast of current social conditions and expectations. That is still the position. Close quotation. So Lord Bingham talked about this in his essay, The Judge's Lawmaker, and he said, where citizens have organised their affairs on the basis of an understanding of the law, where a defective legal rule requires detailed amendments, qualifications, or exceptions, the issue involves a matter of social policy on which there is no consensus, or when the issue is outside of the ordinary judicial experience. Close quotation, says that they should be loath to make laws, but sometimes they're simply obliged to. And in interpreting the law is to some extent making it, as Lord Denning said, they must look to the intendment of Parliament. That's a term of art, intendment. Okay, so how much can they innovate? Well, they introduce novelties occasionally, but they need to maintain the equilibrium between the different needs of common law. Some of these are the need for predictability in law, the need for certainty, the requirement for adaptability, and the need to do justice in a particular case, and the need to refrain from trespassing on what is rightfully the province of Parliament. So they keep to their own appointed limits. So Lord Dyson said this about the power of the judiciary. In deciding whether to develop the common law or to leave any change to Parliament, the courts should apply some overarching principle. Some judges are more cautious than their colleagues, others more adventurous. But despite the difference, the common law continues to involving the life of all of us. Anyway, so I don't think it's really much disputed that judges do make law. The question is under what circumstances, and should they make it? Some will say that they do, but they shouldn't. All right. So let's examine whether they should frame law or not. Courts can make law very quickly without political opposition. So Parliament often has a bit of a political logjam and can't get through these things. So Parliament, these mistakes in legislation can be put right by judges. Some people say that creates a democratic deficit. So the Human Rights Act 1998 grants the judiciary the powers to make law in politically contentious areas. So anyway, Lord Sumption says that, and he said the law made in Europe by unelected judges is changing the law in the UK in a way that is democratically unaccountable. So Lord Sumption went on to say this in 2019. In the last 3 decades, however, there has been a considerable change of judicial mood. The courts have developed a much broader concept of the rule of law, which greatly enhances their own constitutional role. They have claimed a wider supervisory authority over other organs of the state. Close quotation. So when have judges made law? Well, for example, there was R&R, marital exception 1992. That was the thing about a man couldn't rape his wife even if he had intercourse with her against her express wishes. That was no crime because she had irrevocably consented to intercourse by marrying him. So Lord Dyson said that they had needed to change this. This is what he said. This change did not require any difficult policy choices to be made. It was uncontroversial, widely welcomed at the time and long overdue. It is and was inconceivable that Parliament would reverse the decision. Close quotation. And indeed, they have accepted it. I never know if a single person said they should change it. It was an anomaly. Perhaps it would have been addressed long before by Parliament, but it wasn't. And so the judges could change it in 1 second. There was R against Brown, 1993. In this case, some gay men were meeting up for sadomasochistic parties, and they were injuring each other quite badly. But this was not unconsenting. This was actually bodily harm. It was a breach of the Offences Against the Person Act. So anyway, the situation had not been dealt with by the courts before. But remember, you not violenti non fit injuria. On the other hand, some injuries are so bad that your consent doesn't operate. There was also R on the application of Nicholson and another against the Ministry of Justice in 2014. And the courts wouldn't step in here. This man who wanted to die, he was very physically disabled, but he couldn't take his own life, he couldn't put poison in his mouth, he couldn't inject himself with something, he couldn't shoot himself. So what was he to do? Were they going to allow assisted suicide? But that would be against the Suicide Act. So the Supreme Court said, we're not going to legislate on this. It's up to Parliament to either keep the law the way it is or change it. It would be wrong for us to intrude into the political arena. So, and they're not even going to make a declaration of incompatibility with the European Court of Human Rights. So Lord Sumption said this: where there is more than one rational choice, the issue may or may not be for Parliament, depending on the nature of the issue. Is it essentially legislative in nature? Does it by its nature require a democratic mandate? The question whether relaxing or qualifying the current absolute prohibition on assisted suicide would involve unacceptable risks to vulnerable people is, in my view, a classic example of the kind of issue that should be decided by Parliament. Close quotation. So they left it up to Parliament. So this is what the Lord Chief Justice said about this, about whether the law should be changed by Parliament or the courts, in a case called Nicholson and Lamb. Okay, the short answer must be that the law relating to suicide cannot be changed by judicial decisions. The repeated mantra that if the law is to be changed by Parliament does not demonstrate judicial abnegation of our responsibilities, but rather highlights the fundamental constitutional principles, the circumstances in which life may deliberately be destroyed before it's completely its natural course, and if so, in what circumstances, by whom, raises profound sensitive questions about the nature of our society, its values and standards, on which passionate but contradictory opinions are held. For these purposes, Parliament represents the conscience of the nation. Close quotation. So he said that it would be really unbecoming for judges to get involved in that. That's not their role. This is an explicitly political matter, and Parliament must give its ruling on that, not the courts. Okay, so that's enough from me for right now. Bye.